but I've been representing kids with disabilities for a long, long time. And as the presentation will reflect, Jill and I have been experiencing many, many more calls from parents whose kids are experiencing bullying of late than I've experienced in the past. And it seems to be both a growing problem in terms of what kids are experiencing and a growing problem with respect to the difficulties of schools in responding to the bullying. So this is a timely presentation to deal with what unfortunately many kids are experiencing these days. Jill.
Hi, I'm Jill Calian. I've been practicing in Matt's office for about 3 years now. And prior to that, I had other experience working as an attorney in this area. I've also done a lot of public advocacy work in my local community, and I'm a parent of a child with a disability as well. And we're real pleased to be able to talk to everybody about bullying today. As Matt said, there's been a kind of an uptick in the cases that we've experienced coming into our office. And so just by way of overview about what I hope we can kind of cover today, we're going to talk a little bit about, why we named this In the Heyday of the Bully. Why was that the title to this presentation? And we're going to speak to the state and federal laws that protect students from bullying, discuss other mechanisms and just practical strategies that people can leverage to protect, whether it's your child or your client's child. And then I thought we'd talk for a bit about how we might change the climate to make it less conducive to bullying. So turning first to the heyday of the bully, why do we call this presentation that? It seems that there's been a bit of a shift in the political, cultural environment in this country, where there's a great deal of force and coercion being used on the national stage. And that's part of the atmosphere, and our kids are breathing in that atmosphere. And I think they're seeing some very strong arm tactics that are being used with our allies, our adversaries, with governmental institutions and private institutions, law firms, universities. There is a lot of forceful use of power, using money as a cudgel, and assertions of extra legal authority, a lot of kind of bravado and name calling, retribution, intimidation, and of course, othering of citizens, of people who are non-citizens and other protected groups, and an effort to just erase gender identity and gender fluidity altogether, and the use of insults and nicknames, and just kind of a meanness about the culture that we feel like is then influencing our kids, because that's what they see being modeled at the very highest level of government. And of course, open mockery of persons with disabilities, and gross information about disability. Probably everybody on this call is familiar with that recent quote by Robert Kennedy Jr. about autism that was experienced as really hurtful to a lot of people in the autism community, because it made such a gross overstatement about what autism is like, and its impact on families. And it ignored the contributions that people with autism have made in so many ways to the community, and the joy that those kids often bring to their families. So we're contending with that as well.
I want to come back to this picture of Donald Trump and the reporter for just a minute, because I think for a whole lot of people, this incident embodies what bullying is and looks like, and it's just pretty shocking to have, not only in private but in very public settings, the president of the United States engaging in this type of behavior. And it's relevant regardless of your politics, because bullying is something that is adopted often by bullies when they see other bullies having power and gaining social currency by using bullying. And conversely, opposition to bullying needs to be modeled, and disapproval of bullying needs to be modeled. And there needs to be both messaging and a recognition that bullying isn't tolerated. So when the person who's the most powerful person in the country is publicly doing this, it would be inconceivable that kids are not picking up these messages.
Absolutely. So in addition to that disinformation piece, there's also been, as I'm sure everyone is aware, a clampdown on diversity, equity, inclusion, and accessibility, both in government agencies and certainly in the realm of education, where, you know, the Department of Education has now basically made a pronouncement that states need to ensure that the schools within their states are not promoting these ideas of diversity, equity, and inclusion. And that it has a correlation to bullying, because when children are not taught these values, it becomes easier for them to other the other kids, to not appreciate the shared humanity that connects all the students and the kids in a school. And bullying flourishes in that environment that condones and even prizes the opposite of these things, right? That supports homogeneity and inequity and privilege, exclusion, marginalization, and inaccessibility. So that removal of those values and that implication that those values are somehow not to be prized or not to be valued in our schools is also sets a certain kind of a tone for the school environment. At the same time, there's been a reduction in funding for mental health supports. Recently, the government announced that it was going to stop paying out about $1 billion in federal grants to schools that had formerly been used to hire mental health professionals, including social workers and school counselors. And those grants were part of a 2022 bipartisan Safer Communities Act that was enacted after the Uvalde school shooting incident. And I don't want to oversimplify the relationship between the lack of mental health support and bullying and school shooting. I'm not going to suggest that every school shooter is a bully who didn't get appropriate mental health supports. It's not so linear as that, but
Almost.
there's a correlation. There's definitely something to that. What are you saying, Matt?
It's almost linear.
Yeah.
It's pretty close to linear. Yeah.
Yeah, there certainly are studies that show that the lack of mental health support correlates to bullying and also to conflict and aggression and violence in school. Because if you think about what do mental health services scaffold, it's the ability to resolve, to understand and process feelings and to resolve conflict without having to resort to that kind of violence. So if you take that piece away, what's left is to be very, potentially aggressive or conflict based in these situations. And then relatedly, there's been a reduction in social emotional learning. There's been some political pushback against schools who use social emotional learning as part of the curriculum. The Department of Education recently said that some schools have sought to veil discriminatory practices with terms such as social emotional learning. So there's this idea that somehow social emotional learning is suspect, that it's, that there's a hidden agenda in social emotional learning to advocate for progressive extremist ideas. And so there's been some real pushback against that. Some states have even introduced bills to end social emotional learning in various states. It's not really an altogether new thing. There's a cite here to an article from 2021 called "Conservative Activists Call Social Emotional Learning a Trojan Horse for Critical Race Theory." So the pushback started some time ago, but in any event, it's something to be on the lookout for, because again, that social emotional learning, like the mental health supports, is important for the school environment, to give kids the tools that they need to be able to moderate difficulty, and conflict, and resolve things in a peaceful, not confrontational way, and to understand the implications of their acts on other students.
Let me just add here that
Yeah.
actually the Department of Education, in fact, sent out a notice to all public schools saying that if they were using social emotional learning programs, that they were at risk of having their federal funding cut off and or being investigated by the federal government for civil rights violations, which Jill's about to talk about. But thankfully, there is litigation pending to block that, and it's been paused, but it's, I would say, pushback is a benign way to put it. It's active hostility and concrete action to undermine and reverse social emotional learning issues. There's really, it's hard to imagine a more critical element of school programming in relation to bullying than social emotional learning efforts. And notably, as Jill points out, it is built into Illinois state standards that schools have to maintain social emotional learning programming.
Yes.
To
Yeah.
preserve.
Illinois does have social emotional learning as part of its learning standards, and that is still in place. But there has been, at the same time, this real attack on the OCR. I'm sure you all have heard about. 7 civil rights enforcement officers were shuttered, including the one in Chicago. And the reason that this correlates so strongly to our presentation today is because the OCR, the Office of Civil Rights, was formerly a venue for people bringing disability discrimination claims. And it was also a pretty accessible way of bringing claims for families who might not have hired lawyers. They could file a claim for disability discrimination. But now, because of the reduction in the workforce, and I think there's another 35% cut of the OCR budget in the most recent budget proposal that's being debated now. With this pare down of OCR, there isn't the ability to investigate. There isn't the ability, and frankly, there isn't the will to investigate these disability discrimination claims. There have been recent articles. There was one in the Tribune the other day about a school in Illinois that had previously had issues with frequently calling the police on students who had disabilities. That investigation was underway, but because of this interruption to the OCR, that investigation is now not being pursued. There was also a good article in ProPublica the other day about the Idaho school systems and the halting of the investigation in Idaho. So what we're seeing is about 6,000 pending claims that were in the OCR that now are not being pursued. And the other piece is that there just isn't the political will within that organization or the mandate anymore to really to pursue disability discrimination and investigate those claims. The OCR is continuing with investigations, but its priorities have shifted so that it's now looking at things like gender neutral bathrooms or trans women athletes, or alleged anti-Semitism or discrimination against white students. So the priority of concern around disability discrimination has really evaporated, and that just is no longer a really active or likely to be successful means of bringing disability claims. So we'll talk now about some venues or avenues that continue to be available, what state and federal laws have to say about protecting students from bullying. Bullying under federal law is defined as within a relationship. So it's a power disequilibrium within a relationship. It doesn't necessarily have to be an absolute power differential, but the point is that the person who is being bullied perceives that there's a power differential. They think that the bully is more powerful, has coercive authority over them, and they perceive that the bullying could be repeated. Whether or not it was repeated, there's a perception that it could recur. It can involve both uh, physical behavior or verbal or emotional or social behaviors. It can range from blatant aggression to far more subtle and covert behaviors. And it includes cyberbullying as well, which we're going to talk about in a little more detail later on in the presentation. But, any kind of bullying through electronic technology can also be considered to be bullying as well. One thing to keep in mind is that the federal law really aims at discriminatory harassment, not really bullying as we may think of it from, when we were kids, two kids just getting into it, one picking on another one. Bullying under federal law is really targeted specifically to discriminatory harassment. So it's about that the child who is bullied is in a protected class, and the bullying is because of that child's membership in that class. So it's picking on somebody because they're LGBTQ plus, or because they use an assistive communication device. So it's meanness, but it's like that targeted meanness and that purposeful meanness.
Let me interject there for just a second.
Absolutely.
Well, the important thing to know here is that being mean per se without the targeted part isn't illegal under federal law, but it's not just being mean because you are in a protected group, but that the bully perceives you or is referring to you as if you're in a protected group. So one of the things that we frequently ask clients when they call reporting that their child has been bullied, it's not always present, but it's often present, regardless of whether the child is in the protected group, is did the bullies use terms like, oh, you're gay, or use the R word to describe a kid, or you're overweight and fat, or you're crazy and you ought to kill yourself. It doesn't matter whether the statement that the bully is making is true. If the bully is making a reference that has to do with the perception of being in that group. And so the language that's used by the bully is very important, even if the child isn't in fact gay or doesn't have a mental illness or whatever else.
Good point. The other piece around bullying under federal law or discriminatory harassment is that it has to create a hostile environment. And we'll talk later on about kind of what that means in the context of education. This is just another graphic way of looking at bullying versus discriminatory harassment. You see that discriminatory harassment requires that protected class piece, that targeted aggression, and the hostile environment. And when we talk about students in a protected class, and it's because those students, I think there's an understanding, are more likely to be bullied. Students who are in racially protected groups, students who are disabled, students who are LGBTQ plus, and students with disabilities for sure are more likely to be bullied. And there are studies that have shown that kids, especially with learning disabilities or attention deficit hyperactivity, are more likely to be singled out by their peers. And then, of course, there's an extra barrier for some students who may not understand because of their disability, may not understand that they are being bullied, may not have a way of turning the bully away or protecting themselves because of their disability, and may not have a way of communicating that they're being disabled to staff. So that is particularly problematic. I mentioned earlier about a hostile environment, that is one of the key pieces to bullying under federal law, and that exists when the harassment is sufficiently serious enough to deny or limit the student's ability to participate in or benefit from the educational program. And in a lot of ways, it makes sense because these federal discrimination statutes are about they're about equality or leveling the playing field, so to speak. So if there's discrimination that takes away a student's ability to benefit from or enjoy the educational experience and what the school has to offer and limit that in some way, then that's creating a hostile environment, and that's actionable under federal law. So, this has been I've been speaking kind of more generally about federal discrimination law, but in particular, we can focus in on Section 504 of the Rehabilitation Act that I'm sure you all know about. Again, this is a statute that is targeted to disability discrimination, focusing on that protected class. And we know that that it has to be bullying that's targeted to that particular class, not just the general meanness, as we've been talking about, and create that hostile environment in order to be actionable.
Did the screen sharing just pause?
I have screen sharing, but I'm on the very last page now. What you're showing is the very last page of the presentation. So if you can just scroll up to, I think should be on number 18, page number 18 of the presentation. There we go. Okay, so this is again the OCR complaint flow chart. I did not make this, but a very helpful graphic for visual learners out there that just shows these are the pieces for bringing a concern to the OCR. As we've spoken about, that may not be a good venue anymore for bringing those claims, but that is the way of thinking through, is my claim actionable? There are also, we can also—
Let me just comment on that. I think as a general matter, many people would say that OCR is not even remotely as viable an avenue to pursue as it used to be. And OCR wasn't a great avenue to pursue in the past, even when it was fully operational. On the other hand, sometimes to get a school district's attention, you need to take action, and filing a complaint with OCR may still provoke greater degree of awareness on the part of the district and some effort to cover itself, because even though OCR has been substantially disabled itself, pardon the pun, the school district isn't going to know for sure that their case isn't going to be one that gets accepted for investigation, because OCR wants to show that it's not abandoning disability complaints altogether.
Interesting. So the IDEA also provides a way of approaching bullying and a remedy for bullying, because in the event that the bullying of a student with disability is severe enough that it results in the student being deprived of a meaningful educational benefit from the school, that's a FAPE denial. So that's actionable as a FAPE denial and could be brought, and we will talk more about this as we proceed, but it could be brought as an IDEA claim, either through mediation or a due process case. The IDEA sets up protections for students who are bullied in a way that deprives them of those benefits. So in the event that you have a student who's been targeted by bullying and has an IEP, the team, you should be convening the team to the IEP team to talk about, well, what is the impact of the bullying on the student? Has it changed their academic needs? Has it changed their social emotional needs? Does the IEP in some way need to be adjusted in order to support that student in this new situation? So, for example, it could be that now they need social work services because they've been bullied. They need to deal with that trauma. It could be that perhaps they require some pragmatic language support so that They're less likely to have misunderstandings with peers that escalate into bullying situations. So you take a hard look at what protections are in that IEP and how it might need to be adjusted. And one thing to be alert for in this situation is that there's no unilateral changing of the student's placement because of the bullying. It should not be that a student is moved to a more restrictive placement because they've been the victim of bullying. And sometimes schools will, that's an easy fix. Well, we'll just move this kid. And so as an advocate or a parent, you want to be sure that your child continues to be kept in the least restrictive environment where they can access FAPE, and that other kinds of solutions that we'll talk about as we move forward are implemented instead that to redress the bullying situation.
And I would add to that, just it's not just that you've not moved to a more restrictive environment, but as Jill will allude to later, the victim shouldn't be the one punished because of bullying. So even a lateral change that takes the child away from their peer group, that takes their child away from a preferred teacher, whatever else, as an easy way to solve the problem shouldn't happen unless the parent is the one who is preferring or at least comfortable with that change. The focus on protecting the student should be protecting them in the environment where they were and addressing, controlling, or removing the threat from the bully.
And sadly, that's the fix that's suggested by school districts all the time. We'll just move this child who's been bullied someplace else. Under Illinois state law defines bullying broader than the federal statutes do. It does not have that narrow requirement that the student be in a protected group and that the bullying be on account of the student's membership in that group. So it's more broadly defined. It incorporates harassment, threats, intimidation, all these kind of coercive behaviors that are contained in that first bullet point, and that's not an exhaustive list. And then the other piece of it is it's that coercive behavior, that humiliation or destruction of property or intimidation, and then it's done in a way that would have the logical outcome of it would be that the student would be placed in reasonable fear of harm to themselves, or that they would have a detrimental effect on their physical or mental health, or interfere with their academic performance, or interfere with their ability to participate in from benefiting from services, activities, or privileges. So this is one distinction then between the Illinois law and the federal law. It doesn't require that being in a protected class. It does.
Let me also
Yeah.
comment here, because we had a number of people who were joining the webinar from other states. States have different, there's no national standard for what a bullying law should be, or even a national requirement to have a bullying law per se. And so you need to consult your state statute. Some of them may be as strong or even stronger than Illinois'. Some may be very weak and provide very little help, or perhaps none at all. We didn't look at other states, but that's something, if you're from another state, that you want to check out.
And of course, the Illinois bullying statute also incorporates cyberbullying, which is a huge issue these days, of course. That's bullying through the use of any form of technology, any electronic communication, including email, texting, instant messaging, internet communication, creating fake web pages or web blogs where the student pretends to be someone else, posting material online. It's pretty encompassing, and that is a huge piece of bullying as well these days. So there's a number of unique concerns around cyberbullying. This was something we didn't contend with 20 years ago, but now studies have shown that about 15–16% of students, high school students, experience some form of cyberbullying. And it takes place, one of the reasons it's so sort of pernicious is that it takes place in this realm where parents and teachers aren't. They're not there monitoring, they're not there, they don't probably understand it very well. They're not supervising that realm, and so they don't see it. They may not understand it. They may not understand the subtleties of the comments that are made or the emojis that are posted, and just the way it operates. And another piece of cyberbullying is that there's just no escaping it. In the kind of the old days, if you had a bully at school, at least when you went home, you were safe from that person. But with cyberbullying, it's all pervasive. The kids have their phones all the time. And so at any time when they're at home or on the weekends, they could be subject to seeing this very hurtful and bullying conduct. And the images can be shared publicly very quickly. As we know, it's the speed of light to share things. So images and messages, it can be broadly shared to strangers so widely and so quickly. And it also can disappear very quickly because some of those platforms are programmed to remove the messages after a very short period of time automatically, or they can be erased. It makes it hard to be able to have evidence that these things occurred because they disappear so quickly. And also, of course, AI allows for that creation of false and nefarious content that's potentially just so harmful, unfortunately. Can create these, false images of the child being someplace they weren't or doing something they didn't do, just potentially so destructive. And so it can happen anywhere because of the cell phone and the mobile devices. And so when we think about bullying, it's traditionally in the school, but we also understand that can also happen on a bus or a field trip. But in terms of cyberbullying, can happen if the student is utilizing any kind of school provided equipment, a school computer or a network. But it can also occur and be within this idea of school bullying, even if it's not school equipment, even if it's not during a school activity, but simply if it causes a substantial disruption to the educational process or the orderly operation of the school. Matt, have you had cases where the student was just completely off-site at home?
Absolutely. And I would say that schools are very generously interpreting the disruption to educational process when they want to. And then conversely, they're very quick to say, oh, we can't do this because it was a private behavior and not affecting school. And that is sort of beauty is in the eyes of the beholder, or bullying is in the eyes of the beholder as to when the school chooses to respond. Melanie, I saw, or Melissa, I'm not sure, it flashed up. If you have a comment, can you post it in the question and answer section, and then we'll be able to see it.
So what the Illinois statute does is require districts to create and publish anti-bullying policies, and you've probably seen those in various districts' websites. They have to make, and then there's sort of some core requirements that are in the act itself that have to be replicated in these policies. So for example, schools have to make a diligent effort to notify parents or guardians of the bullying within 24 hours. They have to provide the victim with information about the availability of counseling, psychological services, and other resources and restorative measures. They have to make reasonable efforts to complete any kind of investigation within 10 days. And then they have to collect data and submit it, data about the bullying within their schools to ISB in an annual report.
I recently had a school district that said to the parent that if they persisted in complaining about the bullying, the principal would have to report that immediately to ISB. And that was being used coercively to dissuade the parent from pursuing the bullying claim. And that wasn't a legally correct interpretation of the reporting requirement. It's also obviously concerning that they were trying to use the reporting as a way of intimidating the parent into not pursuing it, which just reflects the degree to which administrations may vary and often be very hostile to pursuing bullying investigations or taking meaningful steps to deal with them.
Absolutely. So the Illinois State Board of Education does have a model bullying policy for bullying prevention, and a number of school districts just, have adopted that act and that policy as their own. And you can look at it at the site if you want to see the content of it. It complies with state and federal laws. Other school districts have developed their own policy where they have incorporated the requirements of the Illinois state bullying statute, but made it their own with their own timelines and processes. And so you have to look at each individual school district policy to see how they handle bullying, so you're aware of what the procedures are for a particular district that your child is in, or your child or your client's child is in. CPS is one of those districts that has its own policy. It has a policy called Addressing Bullying and Biased Behaviors Policy. And it's its own animal with an Office of Student Protections and its own way of approaching bullying. So you want to be aware of what the ins and outs of each policy are.
And we've found, by the way, that the Office for Student Protections is a miserable form of administrative response to these complaints and can take months to resolve and is oftentimes antagonistic to the victim. So it's in many ways, or well, I don't want to say it's always the case, but we've had several clients who actually felt traumatized by the process of response. And by the way, sadly, I think there are lots of problems with the CPS Office of Student Protections. Other families in non-CPS districts sometimes also report that just complete sense of victimization because of the inadequate or even hostile response from the school administrators.
Is a kind of re-traumatizing for the child and the family. So what mechanisms can be or strategies can be leveraged, certainly in the aftermath of any kind of bullying, in the immediate aftermath? You definitely want to notify the school administration, and then we say document, document, document. So that means just keeping a running record of any instances of bullying, including the dates and the times and where it happened, and if anybody saw it, teachers, staff, other students who were the witnesses, any action that was taken by the district or requested and not taken by the district, or steps that the parents took. You want to take photographs of injuries. If a child has been hurt, I do encourage parents to take a picture of it, of whatever the injury was, so that there is a record of it. And you want to be sure that the district is preserving any videos that it may have of the incident. So if there's a camera on the bus or a camera in the hallway that could have caught whatever interaction there was between the student and their harasser, you can request that from the school district. The school district may make a big fuss about how it's confidential, but they can potentially redact whatever records or cover up faces, but you should have access to that video, and you want to be sure in any event that it's preserved. So put in that request early, because a lot of times schools will essentially cover over the videos that they take pretty quickly. They just put new video on top of it. So you want to make that request quite immediately after an incident occurs. You want to obtain any kind of a record that's been made if the interaction caused a disciplinary response from the district and they have a file on it. You want to get a copy of that file and see whatever student, for example, witness statements that are in that file. You want to get whatever information the school has, basically. And if you have a student who's been, Matt, did you want to
finish your thought?
If you have a student who's been, who has been physically or emotionally hurt, you really want to think about getting them immediate care for a number of reasons. First, from a mental health perspective, if that student is being bullied, they may really benefit from having a therapist to speak to about it, to process the event with. It may be beneficial to them, and then it also may be strategically helpful because then there's an additional record coming from that therapist of what the child has recounted to them, and there's additional evidence of the injury that they have experienced. So sometimes when we have clients who say, "Oh, my child was traumatized by this bullying," and we'll say, "Well, did you take your child to see a therapist if they have had any kind of mental health support for this?" And it's better if the answer to that is yes. It's better for the child if they can obtain that kind of support, and it's better from a strategic standpoint of building a record and having proof of what occurred and its impact.
I would say, to add to that, we have some clients who say, well, my kid's the victim. Why should they have to go to see a mental health professional when they're the victim? And we're saying to the school district, what happened was very serious, and we need you to intervene and take it seriously. Jill is correct that it may help to document both add credibility to the fact that it may have happened because the kid's reporting it in real time, and add credibility to the fact that the kid's been hurt by it. It also adds credibility to the fact that the parent is taking it seriously, and they're not just looking to the school to do something, but it was so serious that they're doing something about it themselves. And so that's really a very strong action that's needed, and we really push that very hard with our clients.
Absolutely. And same with physical injury. If you have a child who sustained a physical injury, take them to the doctor, get the medical records from the physician. In terms of reporting, most, well, all districts really are going to have some kind of reporting process because that's part of the state act. So this is just a sample of the first page of a bullying incident report that from District 65. As we said, CPS has its own process for getting information about bullying with the Office of Student Protections. Whatever the process is, report it, keep a copy of what you reported, and then take concerns up the ladder of the administration if they're not immediately addressed. And then to that point, if they're really not addressed over time and it is persisting, the next kind of leveling up of reporting is to write something called the Gebser letter. The Gebser letter is named after a Supreme Court case, Gebser versus Lago Independent School District. And really the bottom line to that is that to that case is that if you have a situation where a student is being it's kind of a prolonged or unaddressed bullying or harassment, you want to bring that concern to the level, to a high level. The district school board, the superintendent, and you want to notify these people who have the ability to fix the problem that there is a problem. So you're telling the school board and the superintendent, I'm submitting this letter pursuant to the Supreme Court case. I want to put you on notice. You have control over these people. You have control over this place. This is what has been happening to this child over time. This is how they've been made aware of it by the family. The family wrote an email on this day. The family talked to the principal on this day. The school district is not responding to it. This is causing a continuous harm, and we're going to hold you, responsible for that if you do not intervene. And here are some ways that we think you should intervene to take action.
Let me
Yes.
just comment that the Gebser letter is a strategy to put the district on notice and trigger, in effect, to raise the bar or level up, as Jill is saying. You don't have to have a lawyer to write a letter that's a Gebser letter or the equivalent, but it is certainly more impactful if it comes from an attorney, because it will be seen as a more serious threat of liability or holding them accountable for violence.
So in addition to the Gebster letter, there are improvements to the IEP or the 504 plan that can be made. We touched on that a little bit before. That if you have a child who's been bullied or harassed and they have a 504 plan or an IEP, you should convene that team and talk about how their needs may have changed in ways that would require adjustment to their plan. Ask whether there's been an academic impact and address that through the document. And then, as we said, be wary of any kind of an intervention that is removing the child or punishing the child who's been bullied in one way or another. You want to be sure that the team is advised of the bullying conduct so that the professionals in the building who are interacting with the child on a regular basis know that this occurred and can be on the lookout for continued harassment. Keep in mind that the child who was bullied or the bully themselves may require an FBA or a functional behavior assessment or a behavioral intervention plan. That may be one way of addressing the problem. And again, getting services to the student who is doing the bullying is really important too, because they're the other side of the equation. And if you can stop the behavior through those kind of interventions, that's the biggest win of all.
One
Another,
thing that
yeah,
gets tricky about that is schools will often take the position that they can't discuss anything about the aggressor because of privacy issues. And so they won't share anything about, other than saying, we've addressed it or something vague like that. They won't actually express specific steps that have been taken. And if they are removing that student, that might be noticeable, or changing them to another class. But other than that, they're typically not going to be willing to explain what's going on. And that's a source of great frustration and consternation for families, because it's hard to feel safe if you're not being informed of what the safety steps are in terms of the perpetrator.
very true. Right. And same with disciplinary measures, is that we get a lot of parents who will say they want to know essentially how the perpetrator has been punished, so to speak, and the school is often not going to share that information in any kind of specific way. Another thing, a great vehicle is the safety plan. So you have a child who's been bullied or harassed and picked on, and you go in and say, they need a safety plan. I want to sit down with the team and develop a proactive plan to try to avoid this kind of behavior from recurring and this kind of injury from recurring. Very important that it center the student themselves, as we talked about, that it not, burden the student who's been victimized, but also that it takes into account what their thoughts are about how to remedy the situation. I think an appropriate kind of example there is that sometimes schools want to say, we'll use a restorative practice, and we'll essentially have the bully and the bullied child sit down together, and they'll have a peace circle, and they'll smoke a peace pipe together or whatever. They'll make up with each other. And sometimes from the perspective of the child who's been victimized, that is a really terrifying idea. They do not want to be with the child who's been aggressing against them. They don't want to share space with them. They don't necessarily want to be outed as I complained about you, and now and I'm more subject to retaliation. So always important to ask that child how they want to fix the situation and what they see as the problem.
I would add, just in my experience, restorative practices are a great concept in theory, particularly in the context of bullying situations. They're rarely agreed to, rarely even offered by the school district. And then the other thing to be mindful of is often both the bully and the victim have disabilities that may actually interfere with their ability to make meaningful use of the restorative process. And unless you have very skillful people running the restorative process who are able to understand things like that the kid has a language processing problem, or the kid has difficulty with cause and effect, or the kid has a difficult time understanding the rules or whatever, they may have an expectation for a restorative process that may work with other kids, but may not work with the two particular kids or group of kids involved.
Very true. Usually in the safety planning process, I always want to know, well, where was that child bullied previously? What were the conditions under which it happened? Because let's try to not have that scenario or that environment available again. And often bullying happens in, no surprise, unstructured times. It's the lunchroom or recess, it's passing periods, it's after school, in the locker room. And so I want to understand where it occurred and then think particularly about separating the child from the bully in those situations, or being sure that there is more supervision and more adult eyes in those places and times. I want to also be sure as part of the safety plan that the student knows how to report future bullying and that process is accessible and confidential. So you have a student maybe who has difficulty with dysgraphia or has intellectual disability, you're not going to give them, oh, here's a long form you can fill out to report the bullying. You have to have a process that is meaningful to that child's ability, and it may just be finding that trusted adult and being sure that child has access to the trusted adults in the school environment. Should be collaborative and creative, build a 30-day check-in period, some other ideas around increasing adult monitoring, having a peer buddy for the child, check-in, check-out process, often with a social worker, a good way of kind of just keeping tabs on what's been happening during the day. Is the child feeling safe? Kind of a pass to leave the classroom. I had that recently in a case where the student, was perceiving subtle bullying happening in the classroom. So just having that red pass to be able to leave, or the opportunity to leave before 1 minute before the transition period in the hallway. So if the bullying is happening in the hallway during passing periods, the student isn't in the hallway with the bully. You want to be sure that there's social work available to that students, and be sure that they're protected in potentially dangerous situations like the high school bathroom, and like the student who's walking to their car after school. Those seem to be, especially at that high school level, especially particularly fraught situations for students.
I want to make 3 expansions on Jill's comments. First, the identification of an access to trusted adults is very important, and it doesn't necessarily have to be a special ed staff member or social worker. Sometimes there is no trusted adult, and that's very telling by itself as a concern. The other thing is that sometimes the social worker can be enormously helpful, and sometimes the social worker is perceived as a non-trusted adult. And so you have to be both thoughtful and strategic about how you're going to get, in effect, counseling or support services to the student with someone who's likely to be trusted and effective. The other thing that many of you may have encountered about related services more broadly, but is especially true here, is that sometimes the plans will say access to the social worker as needed, and particularly if it's a person that the student doesn't know. But even if it is, the students often are reluctant to seek help. And it's important to say, providing social work services at least this many minutes on a weekly basis and as needed, as opposed to only as needed, if it really is felt that this kid really needs support from the social worker or comparable person.
100%. Other things just in the environment that you can think about is that the school could provide anti-bullying events and information, can put up posters about bullying that have information about how to report bullying. You want the school to be creating a culture that makes students feel safe and encouraged to report bullying when they see it. just generally, so that if there are bystanders, that they're becoming upstanders who are reporting that they're seeing a student being coerced or bullied or harassed. Staff training around bullying and harassment is another important tool that can be used. Sometimes the teacher or the staff member is the bully, then there are legal protections against that as well.
And in that situation, I'd think seriously about reporting it to DCFS.
Yeah.
Which technically the school itself should be doing as well, but if they're not, or even if they are, the parent can make that report.
And, you know, just in general too, just acknowledging that bullying is, it's really pervasive, and it's very difficult to ferret out and address. One other mechanism that can be used when things are really going south and are not working in the school district and in the school, and this is particularly true when the trust relationship between the parent and the school has been broken, or the student just frankly no longer feels safe in that environment or is in a school refusal mode. You can look at, well, is there another school that the student can attend? And as we said before, it's not your first response, but it's a response to pervasive bullying that hasn't been addressed, and students who just are not feeling that they are welcomed or safe in that environment. CPS does have a process for transferring. They do have a process called the safety transfer. You have to go through the network chief in order to obtain that. There is, for districts that have over 500,000 students, there is a state law that provides for transfer in the event of where you have a student who's been made a victim of particular types of violent crime. And then in those smaller districts, the problem is, of course, sometimes you get families where like there is no other school, there's only one middle school in the district. And so that a transfer to a parallel school within the district isn't possible, but there is the possibility still of transfer to another neighboring district, although it's not an easy process. Matt, have you ever had success actually obtaining an interdistrict transfer of a student?
Well, I have, but it's not something that the school that the kid attends has control over, because it can only happen with the permission of the receiving district. By the way, just a tangential minor note, but the Illinois statute has all sorts of references to cities over 500,000 students. That was written specifically for CPS, though CPS now only has 323,000 students. So technically, that statute doesn't even apply anymore. But no one that I know of questioned that.
Interesting. I didn't realize that. Other legal remedies, as we talked about, if you have bullying that's interfering with the student's ability to access FAPE, you could have a due process claim or a mediation claim. And you're, of course, in either of those avenues, you're not going to obtain real damages for the student's experience, but yet you could have remedies that were framed around changes to the IEP or a transfer or potentially reimbursement for something like mental health treatment, some intervention like that. You can file a state complaint with the Illinois State Board of Education. And not always very helpful, I think, but a possible pressure point with for a possible way of exerting pressure on the school is to file that kind of complaint, because it will at least, engender an investigation. Probably that sort of complaint is more useful in situations where the school is not protecting students from bullying generally, and it's more of a widespread issue, or they're maybe not protecting a particular class of students. They're not paying attention to a certain kind of bullying, or they're not following their own policy. There's the OCR complaint, but as we talked about, has less utility at this point. You can file a claim with the Department of Illinois Human Rights. Matt, you want to talk about those last few on here?
Sure. And to be clear, the first couple of things Jill is alluding to relate to kids who either have already been identified as qualifying for IDEA or 504 protection, or who ought to qualify for IDEA or 504 protection, even if they haven't been identified yet. So those are not particularly available for kids who are just being bullied because the bully's mean and the kid is being singled out for whatever reason. The complaint to the Illinois Department of Human Rights is a potential avenue, and that might be true in other states as well, for any kid who's subject to, I don't want to say garden variety bullying, because sometimes bullying can be awful and traumatic, regardless of whether the victim has a disability or not. But in order to maintain a claim for bullying that's related to a protected status, and by the way, it doesn't just have to be disability. It could be disability under 504 IDEA or ADA. It could be this bullying based on sex or sexual orientation under Title IX. It could be bullying based on race or national origin under Title VI. There are a variety of different federal civil rights laws that provide protection for students regardless of disability if they're belonging to a different protected class. And those laws all provide a mechanism for filing a lawsuit in court if you can show that there's been discrimination, including bullying and a failure to respond to the bullying or the creation of a hostile environment. And then in Illinois, and this is very recent to Illinois, it may or may not exist in other places, but there is a recent amendment to the Illinois statute called the Illinois Civil Rights Restoration Act, which provides that if any of these federal civil rights laws have been violated, that you can bring a claim for damages in relation to any violation of these laws with a minimum of $4,000 per claim in damages. And there's even an argument, though it's unclear who's going to win the argument, that you can bring the argument that it's $4,000 per day of violation, not just $4,000 a day for the total violation. That said, litigation is a last resort under any circumstances. And sadly, litigation probably is only going to make sense when the level of trauma or injury to the student has been extreme and the ability to repair what's happening is either impossible because of the complexity of the situation or impossible because of the refusal of the school district to cooperate. Some other things that can be done to address bullying that are not dependent on going to federal court: you can file a police report, and that's of mixed utility in my experience, but I've had a number of clients who've done that. It's certainly a way of upping the ante. And you can also file a report with DCFS. To be clear, DCFS doesn't have direct jurisdiction over child-on-child bullying, but they do have direct jurisdiction over the failure of the school to protect the child from bullying. So the report to DCFS wouldn't be because the bullying occurred per se, but rather because of the inadequate response or lack of response from the school, unless there is a DCFS report, as I alluded to earlier, if it's the staff member who's bullying. And I had a recent case which staff member was guilty of a whole pattern of bullying with the particular student who came to me. And as we investigated, it turned out that there was a many-year history of the staff member bullying students. And our student, by virtue of our intervention, was able to get good preventions, steps to actually protect them, as was true for their siblings who were going to have this teacher later on. But as is often the case, the school district was unwilling to publicly concede, publicly meaning to us, any steps that would have led to dealing with this teacher on a broader basis. Well, we can't reveal any information about the teacher because that's protected under the Illinois Personnel Records Act. We can't talk about other students because that's protected under student privacy and so on. And so they actually got very hostile and said that the parents were basically ought to be thankful that they'd gotten what they'd gotten and they weren't going to deal with the broader issues. There is also something that I've had occur a couple of times in a worst case scenario. Parents have the right to request something called an order of protection, which is issued by a court. And the order of protection can include a statement that the bully can't have any involvement with the victim under any circumstances, or even come within 500 feet of them or 1,000 feet of them or whatever. And that's significant because, assuming that there's a protection in place, the school district has to enforce the order of protection, and that would almost certainly mean that the school district would have to find another school for the bully to attend, because they couldn't actually implement the order of protection effectively without the student being the bully being placed in another site. That can be done with an attorney, but it actually doesn't require an attorney to do. And you can contact the state's attorney in your jurisdiction to do that, or to just assist you with doing it. And I've had a couple of instances where a parent was able to get an order of protection on their own. Unlike the school system, my experience is that frequently the courts are pretty willing to give an order of protection without a whole lot of production or needing a long, complicated adversarial process or whatever. As if they're convinced that the bullying's happening, boom, that's just done, and there's no big fight about it. So that's kind of a last resort, but it is a viable action that can be done. Are we on the share again, or did I?
Yeah, we lost the share. So I think at the last part of our segment is to talk about shifting the culture back to protecting students from bullying. You know, we spoke at the beginning about how there's this direction towards kind of more adverse and coercive resolution to issues, and extortion and threatening and name calling, and you know, how do we get away from that? So some ideas are that we whether you're in the school or you're representing a parent in the school, is that the parents stand up for the appropriate use of language, because in a lot of ways, you know, language drives action and thought. And there's a concern now, I think, that because of the getting rid of diversity, equity, inclusion, and accessibility, that we may return to more kind of I'll call it regressive language, but where we start to call kids retarded, or to use other derogatory and demeaning terminology like that. And so one thing that we can do is just to, if we hear that, to stand up and correct it on the spot and in the moment. We can be sure that there's broad representation of students with disabilities, despite those DEI banning requirements. If you look closely at what the Q&A from the Department of Education says on this issue, it does say, oh, well, you can still talk about awareness or cultural activities or groups, as long as they're not exclusive. So it is certainly still okay to have representation and to push for disability awareness. So, you know, your school should have those books in the classroom and in the library about disability, and there can be posters and discussion around disability and disability rights, the history of disability rights. You can also support and pursue school-wide approaches that cultivate a positive school culture and climate, advocate for continued social emotional learning, for continued support for mental health in the school system, and also help, you know, when the school is looking for that extra, you know, parent to supervise on the field trip or whatever, be that parent, or encourage your client to be that parent, because that extra set of eyes may be what protects a student from being bullied. And you can also think about just reducing places, if there are physical spots within the school that are kind of conducive to bullying, that are, you know, private or not well supervised. Think about how those could be eliminated. And then on that point about DEIA, Um, Another thing that can be done, I think, is to try to reframe our language based on that constraint. So, all right, if we're not supposed to be using those terms, how can we get across the same idea? And I think it's really quite possible because a long time before we had, DEIA, we had kindness, we had Mr. Rogers, we had ideas that we needed to teach children that social emotional learning is really important, that we need to teach children how to be good members of society and contribute to their community, civic values. So I think we can still try to get the anti-bullying point across using other language. So maybe a couple examples, instead of saying the student needs a ramp to get into school because they're disabled and can't walk up the stairs, we say the student needs an education like all other kids, or everyone needs a way of getting into school. And a kind of benefit to that framing too is that it doesn't focus on what the child can't do or that they are disabled. It focuses instead on the universal need, which is what unites us with each other. So then in the bullying context, instead of saying that kid needs special protection because from bullying because they have a disability, we say every child deserves to be safe at school, or let's create a community where all children are welcomed. And I think this goes too, the language of disability has evolved over time. We used to say kids have special needs. I'm trying to get rid of that expression myself because really their needs are not special. And that's what this kind of framing emphasizes, is that they don't need these things because they have a disability. They need these things because they're human. And I think that kind of language can accomplish the same sort of goals around community building and peaceful resolution of conflict. Many other forms of activism here on the list, joining the school PTA to support positive school culture, or if there's a district level organization, some districts have parent caregiver advisory councils, think about joining it. There may be a parent group of students who have students with disabilities and be part of that group. Participate in a local advocacy group if there is one. I'm in Evanston, part of Evanston Case. Other communities may have something similar, or if they don't, maybe you form one. You can attend and tune into school district meetings and lobby your school district representatives for change, or even become a school district member, run for that position. You can advocate in support of continued mental health and those social emotional learning pieces, organize with other parents when you see that there's a shift in culture, volunteer when the school is looking for additional parent or guardian participation.
I'd add one other thing, which is that, and this relates back to earlier things you can do in response to your particular child being bullied. Volunteering is a good way to get information about what's happening at school. But if your child's being bullied, it's also a good idea to go in and ask the school to observe, and they're required to, within reason, let you come in and observe. And many people say, well, the bullying's not going to happen while the parent is in the room, but actually surprising how many times it does happen. And particularly if the parent is just on the playground and they can see things that are happening on the playground. We have a case right now that's troubling because the student has been physically severely injured, requiring hospitalization 5 different times while at school. And that's bad enough, but it's 5 different students. And that's significant because it's not one kid being a bully with a pattern of singling this kid out. It's really that the entire school is out of control and there's a whole lot of violence happening. It's hard to imagine that there isn't violence occurring against other kids too. So the answer in that case isn't that we need to protect this kid from one bully, but we've got to get control over the overall environment.
Yeah, and I mean, really having that going into observe, or having a professional go into observe, is a great strategy wherever you have the school saying, we don't see it, whether it's bullying or other kinds of the manifestation of the child's disability. That's just a way of, okay, well, how can we make them see it? we have somebody objective go in and observe. That's a great strategy. You can also think about guarding against changes in legislation, future things we may have coming at us from the current administration that could potentially further curtail the rights of students with disabilities or further limit their ability to have any kind of legal resource against bullying. So you can call and write legislators. You can join COPA, the Council of Parent Attorneys and Advocates, if you don't already belong to that super organization that provides not only a lot of educational materials, but also does some really important legislative policy advocacy work. Be sure that students who are accused of bullying, again, that they are having access to the mental health supports. We spoke about that earlier. And of course, model as an individual respect and peaceful conflict resolution, and last of all, vote. So here's a number of additional resources related to bullying. Loyola has a super anti-bullying program that provides support for families at no cost who are encountering bullying. The ADA, Choose Kindness. There's an inclusivity program called Nora's Project that's not on here. ISB itself has resources. So many materials and resources out there on this point. I know we have a difficult form here because of speech not being enabled on our programming, but if anybody has any questions and wants to put them in the Q&A, we'd be happy to address them. Matt, was there anything else on your mind as we're looking to see?
I think you've done a great job of covering it. It's excellent.
Good. Well, I do appreciate that you all came to join us this Thursday lunchtime and talk about this issue. It's unfortunate that it continues to be such an issue, and just the number of, I feel like I've written multiple Gebser letters in the last month. I'm sorry to see that there does seem to be an uptick in this behavior.
I think that one other comment to make about that, but just a further complication is that there's clearly a continuing impact from COVID and the remote learning system, and that's making everything more difficult for kids and for schools. So that continues to be a struggle. All right, well, thanks everybody very much. And if you have questions, you can email us. You can go to our website at www.mattcohenassociates.com or email either Jill at mattcohenassociates.com or Matt at mattcohenassociates.com, and we're happy to respond. Heather Bertucci, if you can put a question in the Q&A, I see you've got a raised hand, but we can address it through the Q&A.
Oh, can I get a copy of this recording? Yes, you can. The presentation was recorded and will be available on our website within a few days. All of these type of educational presentations that we do are there on our website. It's a terrific resource.
Okay, with that note, we'll say thanks to everybody. There's one more question.
Okay, thank you for doing this. Would love a series directed at college students advocating for themselves at universities. Get your point. Yeah, in the higher ed context, but don't offer IEP or 504 services. Okay, good point. We'll take that under advisement and consider that as a future topic. And thank you. All right, well, thank all of you for coming this afternoon. We really do appreciate it.
Thanks. Take care.